Do you hear me loud and clear?
Hello, very good to see you.
Okay, good to see you again. It was last summer, August. Yeah, we met last year.
That's right. That's right.
Okay, so actually, we have a 1.5 hour today, but we like to hear more from you about the war in Ukraine, rather than we want to talk each other. So, I mean, you can use the time as much as you want to give us the fully explanation of the situation going in Ukraine, especially from a legal perspective. So, just like you said just before, the Monterey Convention is something we really want to hear about from you.
Okay. Thank you. So I thought, should I just talk maybe 25 minutes and then leave the rest of the time for any kind of interaction?
Yeah. I'll try to find the question and some the comment from audience. Then I'll direct those comment and the question to you, okay, so that you can explain something about that, and then we can see. So I mean, we have ample time, so you can spend more time to explain the contents of your slide. Actually, your slide is big. It's quite big, so we need more time to explain the content of slide.
I'm going to start at slide 19, but I did add some. So I'm going to, I did have some discussion before the conflict began on 24 February, but in the interest of time, I'm just going to start on 24 February.
Okay.
Yeah.
That's good. Okay, time to start. First of all, let me extend my heartfelt gratitude to the Professor Jim and also the old audiences from ROC's audience, and also even I believe the foreign audiences here. So I hope that they will enjoy your lecture. Let me begin with some introduction of Professor James Kraska. He is a chair in the Charles Stockton Professor of International Maritime Law in the Stockton Center for International Law at the Naval War College. And he was the first established chair at the institution and visiting professor of law and John Harvey Gregory Lecturer on World Organization at Harvard Law School. He has served as a visiting professor of law at the College of Law, University of Philippines, and also visiting professor of law and Gujarat National Law University. Mary Derrickson McCurdy Visiting Scholar at the Duke University, a Marine Laboratory and a fellow in residence at the Maritime Center, Hole Oceanographic Institution. So for saving time, it would be better to invite our Professor Jim to explain the war in Ukraine from a legal perspective. So Jim, it's yours.
Thank you very much, Dr. Chung, for that kind introduction. I'm going to share my screen. I have a few slides that I thought might be helpful as we walk through what is going on from a maritime law standpoint and international law of naval warfare in the Russia-Ukraine conflict. Does this slide look okay? Does it display properly?
Yeah, it looks okay.
So there's a lot of dimensions to this international conflict, and international law, of course, applies. This presentation does not focus on the land law of armed conflict, such as the seizure of the nuclear power plant or the use of certain weapons, such as thermobaric weapons, targeting of civilians that you may have seen in the media. use of mercenaries or mistreatment of POWs, or the forcible export of Ukrainian civilians to Russia. These appear to be violations of the law of armed conflict, but instead of looking at the land or the ground war, let's focus on the international maritime law and law of naval warfare. This phase of the conflict began on 24 February, and it's debatable whether this is a continuation of the war since 2014, or is this a new conflict? Under Common Article 2 of the Geneva Conventions, this is a classic state-on-state international armed conflict, and all of the rules would apply. But since there was somewhat of a on-again, off-again lull or periodic pause in the armed conflict since 2014, you might say that this is a new armed conflict. It has been, featured all of the things you see on this slide, with naval forces conducting airstrikes, targeting cities and critical infrastructure, the seaports in the Sea of Azov, including Mariupol. These are threatening maritime safety and security, and the safety of seafarers, as well as protection of the marine environment. And there have been multiple civilian ships that have been struck. When we look at the law of armed conflict, we have to distinguish between the jus ad bellum, or the initiation or start of a conflict, and the jus in bello, that is the law that applies once a conflict is underway. So in thinking about this question of whether this is a new conflict or not, we have to contend with whether Russia has violated the law of jus ad bellum. And under Article 2, Paragraph 4 of the UN Charter, states are forbidden to conduct armed aggression or use of force against another state. And it appears that that has occurred here. And if that's the case, then once an armed attack or armed aggression, in the French version, armed aggression, once armed attack or armed aggression occurs, then states have a right of self-defense. Ukraine is a member state of the United Nations, and now it is engaged in a war of self-defense. So this jus ad bellum piece would condemn Russia for a violation of Article 2, Paragraph 4 of the Charter. That previous issue of Article 2, Paragraph 4 is separate and distinct from the law of armed conflict jus in bello, or what is unfolding day to day. Putting aside whichever party is or is not responsible for the conflict, we have to view the fighting, the fighting itself through the lens or the view of jus in bello and the law of armed conflict. And what this means is that when state parties are in an armed conflict, they may use force. They may use deadly force against the enemy, merely based on the status of the enemy. That is, Russian soldiers and sailors, naval forces, and Ukrainian counterparts may use deadly force against each other without committing a violation of murder. They can kill the enemy and destroy the enemy simply based on the status of those enemy forces. Now, this requires observance of three fundamental principles of the law of armed conflict, LOAC. The first is that the use of force cannot be wanton or random. There has to be a military necessity. in the use of force. The second is probably the most important in this conflict, and that is distinction. The use of force may be readily applied against the enemy forces or military objectives, warships, military members, military materiel, vehicles, army tanks, armored vehicles, supply lines. All of these are lawful military objectives. And those they may be targeted anytime, day or night. But those are distinct from civilians and civilian objects. And both sides are obligated to distinguish the civilians and civilian objects from lawful military objectives. Now, there are occasions where it seems to be unclear whether a civilian or civilian object might be a lawful military objective. We've seen in the media some probably horrific reports of just apparently random killing or torture of civilians by Russian forces. If those are true, it's clearly a violation of the law of armed conflict. If Russia might say, well, these civilians were engaged in the fight against Russia, then a civilian may become a lawful military objective, or a civilian object might become a lawful military objective, but it depends on their nature, location, purpose, and use. So if there is a vessel that's a civilian vessel, let's say a fishing vessel, and it's Ukrainian, and it's secretly laying mines in the water, then even though it's civilian, because of the purpose and use of that vessel, it still might be targeted, even though it's civilian. It would lose its civilian status. There's also the rule with regard to proportionality. So insofar as military objectives, they're limited to those which by nature, location, purpose, or use provide an effective contribution to military action. And there is a benefit, a military benefit from their destruction. It's not just out of anger or out of revenge, but there has to be a military benefit of their destruction. And when that occurs, the third rule of proportionality applies, in which the forces have to make sure that there is not damage or injury that is excessive in relation to the concrete military advantage that is anticipated when the attack was made. So each of these three principles has to be applied every time that force is used. It has to be militarily necessary, not just wanton destruction. There has to be a distinction between military objectives and civilian objectives, and civilians and civilian objects. And those civilians and civilian objects can lose their protected status if they have nature, location, purpose, or use that their destruction would provide a military advantage to the enemy or to the defender, and they make an effective contribution to military action. Even so, the application of force has to be proportional. That is, the force cannot be any more in relation to the concrete and direct military advantage which is anticipated. This is the ongoing siege of Mariupol, and it appears that as Russian forces leave the Kyiv area, the area around the capital city of Kyiv, and they are redeploying through Russia, going northward through Russia and coming back down toward the Donbass. and they are strengthening the siege of Mariupol. The city is under siege, port side city, and the main port for Ukraine on the Sea of Azov. What are the laws that apply with regard to siege? In the Hague 1907 regulations, it says that belligerent forces must take all necessary steps to spare, as far as possible, buildings dedicated to religion, art, science, charitable purposes. This includes hospitals, places where sick and wounded are collected. This does not mean that Russia cannot attack and put Mariupol under siege, but it does indicate that they must spare as far as possible. Of course, this is quite a flexible standard, and Russia might argue, well, it's just not possible to be any more sparing than what they are. There are some other laws that come into play as well, including Additional Protocol 1 of the Geneva Conventions. Both Russia and Ukraine are party to Geneva Protocol 1. And under Article 54, the starvation of civilians as a method of warfare is prohibited. The purposeful starvation of civilians is prohibited. You might say, yes, but what about blockade? Blockade is lawful so long as it doesn't have the sole purpose to starve civilians and that it does not prohibit humanitarian goods to flow through, medicine and food, and these types of goods. The blockade can serve to interdict or intercept military equipment or military assistance going into the besieged city. Also, under the Fourth Geneva Convention, under Article 23, there is a rule that limited evacuation has to be provided, and there's some indication on the ground that there have been International Committee of the Red Cross convoys taking civilians out of the city. And this is somewhat lengthy or convoluted process, but it's a relief scheme for the civilian population. Also under Article 70 of the Additional Protocol, it requires that the parties have a wide range of relief supplies. So even if you say certain food or some type of supply might be used by the Ukrainian military, nonetheless, under Article 70, it would still have to be admitted, or medical supplies, for example, that might help the Ukrainian armed forces. Bombardment is a lawful method of warfare, but there are, under the Geneva Conventions, an expansion of the Hague regulations, Geneva Convention 4, Articles 18 to 23, where there's bombardment is permitted, but not against hospital zones, medical convoys, shipments of medical supplies. But these protections for these medical areas can be forfeited if they're used for military purposes that are harmful to the enemy, in this case, Russia. Distinction also appears to be violated by numerous missile attacks on merchant ships. Here's several that are in the news media, and there are several more. I'll show you. This is the first one that I'll mention is the last one on this list, the Millennial Spirit. It's a chemical tanker and Panamanian flag. It was set ablaze with the crew on board. They were forced to jump overboard, and it was carrying 600 tons of fuel oil south of Odessa. So a number of instances like this have occurred, and that has caused the maritime industry to issue notices to mariners. And so this is the Republic of the Marshall Islands Ship Security Advisory. And it raises the ship security level under the International Ship and Port Facility Security Code, security level 3 for all of their ships, warning them not to enter into the Sea of Azov and to stay clear of the northern part of the Black Sea, and further advising that its vessels should get underway. So the ship registries are warning their vessels, and the ship industry groups are warning their vessels to stay away. There's also NATO warnings and naval area warnings. Mines have been reported north of the line that you see here, naval mines effectively employed for area denial and coastal defense. Their mines may be laid in the water, but they are also subject to the Hague Convention, Hague 8 of 1907. And it says that mines have to become harmless 1 hour after they break free, that warnings have to be given as soon as the belligerents are able, and that you cannot mine neutral waters. What this means is that mines could actually be sown on the high seas beyond 12 nautical miles. And they must be deactivated once the conflict is over. This is an interesting case because the Russian Federation reported that there were drifting mines. Now, many suspect that these mines, in fact, were laid by Russian authorities, but it's not clear if they're Russian or if they are Ukrainian. Russia blamed it on Ukraine, and it provided information that was released as a NAV area warning under the global area warning system. And you can see that I've circled it in red. The Spanish Navy, Spanish Hydrographic Office of the Navy is the NAV area coordinator for the Mediterranean Sea. And so the Spanish Navy has provided this map warning merchant vessels to stay clear of this area. Now, you've seen in the media that there's lots of sanctions. I know South Korea and other countries are participating in sanctions against Russia. And the European Union has been especially stringent in this regard. And this raises an interesting question about France's seizure of the Baltic leader on 25 February. This is only 2 days after the war began. And French patrol boats, like you see here in the left side, intercepted the Baltic leader when it was beyond the territorial sea, and they brought it back into port. And it raises a few questions. The first is this a unneutral act? May France, or for that matter, Korea or the United States, may we take measures against Russian ships on the high seas and still be neutral parties to the conflict? It certainly appears that this is an unneutral act. Now, in past conflicts, oftentimes aid has been provided to one side or the other, and that does not necessarily draw in those countries providing the aid. That doesn't make them belligerents necessarily. But at some point, if you aid one side of the conflict, you might become a party to the conflict. The other secondary issue is a question of freedom of the seas, because freedom of the seas applies, of course, beyond 12 nautical miles. And it's not clear what the implications are if some states can take the vessels of another state, even if they are in an armed conflict. So we will likely see more of this. Now, most of the yachts that have been seized by the Russian oligarchs and billionaires have done so in port. And so if it's a seizure in port, there's a lot easier justification for that seizure under port state control measures. The closure of the Black Sea by Turkey is one of the more interesting phenomena in this armed conflict. So the northwest part of the Black Sea was closed to navigation by Russia, and then Turkey on March 1st closed the Bosphorus Straits. In between the closure of the northwest part of the Black Sea, the IMO met, and Secretary General of the IMO stated that he was concerned about the impact of the armed conflict on global shipping, logistics, and supply chains, and the spillover or the bleed over into neutral shipping and the effect on the global economy. The UN General Assembly, a couple of days later, condemned the special military operation in Ukraine by Russia. But of course, the UN General Assembly does not have any authority to compel states to, to comply with its mandate. Obviously, the Security Council is, would be deadlocked. In looking at the closure of the Black Sea, it raises some interesting questions about Turkey's role and the legal authority of the Montreux Convention. So the Montreux Convention is from 1936, and under the Law of the Sea Convention, it is one of these long-standing international treaties that replaces the Law of the Sea Convention. So the terms of the Montreux Convention apply, and the convention is arguably customary international law, and therefore binding on all states, not just the states that signed the treaty, because the treaty was signed by a handful of states, including France, Germany, Japan, Yugoslavia, Turkey, United Kingdom, and Soviet Union. But it's believed generally that this reflects customary law. So in case of an armed conflict where Turkey is not at war, which is what's going on now, then all merchant ships, regardless of the flag, are entitled to navigate. And if Turkey is a belligerent, then neutral vessels may transit by day. So in time of peace, passage rights are enjoyed through the strait. These vessels have to give notice to Turkey of 8 days if they're Black Sea states and 15 days if they're non-Black Sea states. Peacetime transit by warships is limited in further ways. Non-Black Sea states may not send submarines into the Black Sea. And there are also restrictions on the maximum aggregate tonnage of the number of the types of warships and the numbers of warships that can go through there. And then finally, there's a limitation on the amount of time that foreign warships, such as US warships, can remain in the Black Sea. Now, Russia doesn't have quite the same restrictions, although they can still be restricted. So before this phase of the conflict, remember the conflict started on August 24th, before this phase of the conflict, Russia sent 6 warships and 1 submarine through the strait to participate in military exercises. And so those ships were already in the Black Sea, and then on on 24 February, Russia invades Ukraine, and Ukraine begins a campaign to get Turkey to close the straits. Finally, on March 1, Turkey closed the straits because for a while it wasn't sure whether this was a war or not. And Turkey can close the straits to new Russian ships entering, but not Russian ships that are leaving the Black Sea. All states enjoy freedom of passage normally, but belligerents shall not pass through unless the ships belong to a Black Sea state and they're returning to their home ports. Now, Turkey can close the straits to all warships if it considers itself to be threatened with imminent danger. And that's apparently what Turkey decided in this case. Now, it's a little difficult to argue that Turkey was in danger, but on the other hand, Turkey could say that allowing NATO warships to transit the straits might broaden or escalate the conflict, and that does pose some type of imminent danger to Turkey, even though Turkey is, of course, a member of NATO. So that was on March 1, and the IMO has looked at adoption of blue corridors, safe maritime corridors, to evacuate foreign flag ships and seafarers from the region. But so far, nothing has been very successful in that regard. The IMO is a technical body, and therefore it doesn't really have authority to dictate, particularly to Russia, and it just has lent its support to Ukraine. Ukraine has sought more robust action, but that's not really been forthcoming because the hands of the IMO and Secretary Kitak Lim of the IMO are kind of tied because they just don't have a lot of authority. Secretary General Lim convened an extraordinary session of the IMO, and this was to figure out what, if anything, the IMO could do. They sought to have blue corridors to protect shipping and seafarers and to let them out of the war zone, and then just condemn Russia and express concern for what is going on. And in this extraordinary session, there's fairly strong language used against Russia, condemning the attacks, deploring attacks on merchant ships, and then calling on the safe return of seafarers. So in the meantime, Secretary General Lim has established an emergency task force to advise the maritime industry through the Maritime Safety Division. He's also established a seafarer crisis action team to look at the human rights aspect of this and to try to protect the seafarers. And then finally, the IMO Secretariat continues to review and engage with other parts of other international organizations in this regard. And then I'll end with this final international organization, the International Court of Justice. So Ukraine sought provisional measures at the ICJ on March 16th, just 3 weeks ago. And there was a vote of these justices for the ICJ, a vote of 13-2, that calling on Russia to suspend its operations, to take no further steps or no further action in this provisional measures. But it's an advisory opinion. It's an advisory opinion. Now, what does that mean? Well, it still has a binding legal effect, but as an advisory opinion, not as a opinion that's directive in nature, like an actual ICJ case, because it's only a provisional measures. And the ICJ says it poses international legal obligations on Russia. And what does that mean? Well, eventually you might say that Russia is subject to the law of state responsibility. And that would allow Ukraine or any other injured state to impose lawful countermeasures on Russia for a violation of its international obligations. And with that, I'll stop, Dr. Chung, and glad to take any sort of thoughts or questions you or anyone else may have.
Okay, the first question from I'm not sure the country origin. The question is it legal or illegal for international community to become a volunteer to support Ukraine against Russia?
So there can be volunteers. It's not unlawful. Those are not unlawful soldiers. They have to join the Ukraine Armed Forces or Ukrainian organization. And there's not a violation. There is a violation, though, if they try to have it both ways. They get into trouble if they say that they're civilians on the one hand, but members of the armed forces are fighting on behalf of Ukraine on the other hand. So during World War II, for example, there were U.S. volunteers that fought the Imperial Japanese forces coming to Asia before the United States was involved in the conflict. Also, we had Americans that were going into Europe. If they have to comply with the laws of war, though. They have to carry their weapons openly. They have to be subject to a military chain of command. They have to wear a uniform with an insignia, like on the arm, a badge recognizable at a distance. And this is all to make sure that they are distinct from civilians.
And also it's question about the principle of the use in battle. According to media, the Ukrainian forces conducted a strike against something like a missile site in Russia territory. Is it proportionate, or is it something like being escalatory, or how do you assess the strike?
Yeah, it only has to be proportionate in light of the anticipated military damage. The anticipated military advantage, and proportionality has to do with civilian casualties. So there's no problem of proportionality in striking Russian armed forces. Russian armed forces actually throughout the entire world are lawful military objectives for Ukraine. And that includes striking on Russian territory.
The next question is from a foreign country. What is the UN's role to reduce tension and stop fighting in Ukraine? So far, I have not seen from the news that the UN makes specific policy and take particular measures to restore or create peace and provide security for the local people. So what's the UN's role in this case?
Yeah, so unfortunately, this is one of those cases where the Security Council, which can mandate for all countries or any country, obviously it's blocked, where you have Russia and China on one side and United Kingdom, France, and the United States on another side. So the Security Council is frozen. And you saw that the UN General Assembly doesn't have enforcement authority. It cannot enforce Russia or Ukraine to do anything, but there was a wide majority vote condemning this attack. Yet that doesn't have enforcement authority to compel Russia to stop the attack. It's merely a political statement. You also saw a similar decree by the International Court of Justice, which is part of the United Nations, and calling on Russia to also to stop, and saying that that advisory opinion has a binding effect, but it's not exactly clear what the meaning of that is, or how far it can extend, or what kind of work you can get out of that binding effect. Okay, it's binding on Russia, but there's no enforcement executive. This kind of raises the problems with international law generally, which is that the state is the sovereign entity in international affairs. Ever since the Peace of Westphalia in 1648, within international law, it's acknowledged that there is no greater authority than the nation state, and that states are imbued with sovereignty. And because of that, they are their own sovereigns. And it's very difficult then to compel another state to certain action. In fact, the Security Council has only done so clearly on 2 occasions. Only on 2 occasions has it clearly permitted all necessary means, that is, the use of military force, to repel an invader. The first, of course, was the North Korean invasion of South Korea. And that UN mandate continues or persists to this day. The second was during the Gulf War in 1991, when Iraq invaded Kuwait. And that also provided unmistakable authority under Chapter 7 for all nations to be able to use force against the aggressor. Because it's so rare, and that states, including Russia, are sovereign entities, it's very difficult to compel them. The weakness in international law generally is that there is no international legislature. All of our countries have a legislature, but in international law, there's the UN General Assembly, and it's quite weak, doesn't have authority. There's also not an effective international court, because in the International Court of Justice, in order to have a case to go through, both states have to consent to jurisdiction. And of course, Russia is not going to consent. So there's not an effective case. Imagine in your own country, if an individual goes before the judge and the person is a criminal, and the judge says, "Do you consent to my jurisdiction?" And the criminal says, "No." Okay, then you have to walk free. So we have much more effective domestic legal systems. Finally, there's no international executive that is effective. Like UN Security Council is not an effective police force. Not an effective police force. Imagine if you had to get some large committee that includes criminals before the police can act. That's what you have with the Security Council. And so all 3 of these elements of a functioning legal system are very weak in international law. And that's why we mainly rely on self-help or self-defense, which is what Ukraine is doing. Sometimes you can have collective self-defense. In the case of Korea, we have a UN mandate, and we also have collective self-defense, US Korean Defense Alliance, and other UN partner nations as part of the UN forces.
Yeah. I may agree with the view on the UN. UN General Assembly is not something that can legislate, and also UN Security Council is not a enforcing mechanism like a police force. But in reality, P5, UN and SC, they can act just like a the police and just like the enforcement mechanism. That's the problem. So what they have an allegation that one of P5 is a former Soviet Union, not the Russia. But in this case, Russia is not entitled to those status. So I mean, how valid those arguments that Russia is not an actual P5?
Well, it's a good argument. What I might suggest, though, is that as bad as this system is, I mean, the system is not effective. It fails, except for those two instances, the system has not worked well. I think the only thing that separates the P5 from other countries is that these are still the only countries that have thermonuclear hydrogen bombs, not just nuclear weapons. On the other hand, there may be room for an additional member or two of the P5, such as perhaps India. So I think that this is a political question. It's not a legal question, it's a political question. And you're exactly right that the P5 are deadlocked. There is some type of loose agreement between Russia and China, at least to the extent that they agree on restraining the United States and its partner nations. Maybe Russia and China are not entirely close friends, but they do both agree that they could, that they benefit from restraining the US and NATO in Europe, as well as the bilateral security architecture in East Asia. So it's a real problem.
Yeah, thank you. And also next question is, when there is a disruption in the sea lanes of communication due to the armed conflict, is there an obligation for state involved in the armed conflict of compensation?
Yes, so this would be under the law of state responsibility. Suppose a neutral vessel, like I showed you several examples, a neutral vessel were damaged or sunk, then that is an internationally wrongful act, particularly if it's done purposefully, such as laying mines in the water. Mm-hmm. The problem is you have to attribute the attack to Russia or Ukraine or whatever state, let's just say Russia. You have to attribute an internationally wrongful act to the government of the other state, and then you can seek damages and you can impose countermeasures in order to have reparations. And sometimes these things unfold and it may take years, but actually often they do get paid. Often they get paid. If belligerents acknowledge that they were responsible for the internationally wrongful act, they even will pay, including Russia may pay. Probably not now because their financial system is not, not doing well, but you could imagine 10, 20 years from now. And sometimes it takes decades for these cases to get resolved. I'll give one final example on that. The Corfu Channel case, the mining of the Corfu Channel between Albania and Greece in 1946. The reparations for that case were not paid. Albania mined the waters and the Royal Navy had 2 warships that were damaged. And the warships were going through there. It was part of the Cold War. And the British warships, these UK warships, were supplying anti-communist forces in Greece and Turkey. And Albania did not like it, so they put mines in the water. Albania argued that they weren't their mines, and the United Kingdom took Albania to the International Court of Justice and won the case. Albania did not pay reparations until the 1970s, 30-something years later. So these things often take a long time. You could imagine maybe 10, 20 years from now, if there's a future government in Russia, maybe they might pay some claims.
Okay, next question is about the militia. during the 2014 when the annexation of Crimea Peninsula was made, at the time there was activity of the militia, which is very ambiguous in terms of the principle of using valor. I mean, which principle we need to apply, I'm not sure. But anyway, if there is militia, then how do you treat those militia? They are not the military, they are not the civilians. So which rule we can we use to apply?
Yeah, so these civilians or militia, first of all, there is minimum standards that apply to them under AP1. They have to comply with the laws of war. They have to carry their weapons openly. And the big question here for militia is very similar to what US and its partners faced during the wars in Iraq and Afghanistan, which is DPH. You have civilians that are directly participating in hostilities. And when may those be attacked? When are they a lawful military objective? And there are different views on this question. The US position is that if someone is a farmer during the daytime, but at night they pick up a weapon and become a belligerent, then that person is always targetable. Always targetable, even when they take off the uniform the next day. But that's not the majority position. The majority position is that those individuals are targetable only for such time as they DPH. They may be attacked on their way to conducting a military operation or on their way home. But once they take off their uniform, they're suddenly a farmer again, and they may not be lawful military objectives. So there's a difference of view. The second view is the European or the more progressive view. The problem with that view is that, of course, you provide a sanctuary for those civilians and allow them to engage in armed conflict, and then they seem to have more rights than a military member. Because remember, a military member can be targeted anytime, day or night. Mm-hmm. So why would you allow a civilian to have more rights than a military member? Well, maybe people that have this view, they would say yes, but they're mainly civilian, they're mainly a farmer, they're not threatening during the daytime. So there's a difference of opinion in this regard. One other thought on this is that, remember in 2014, there was the term little green men. The Russian forces were plain clothes, they didn't have insignia, and that we thought they were Russian military, but it wasn't clear. And this is exactly part of the so-called gray zone, or this gray area between peacetime and armed conflict. And there are two prominent cases from the International Court of Justice that say that when you have a violation of Article 2, Paragraph 4, and you have the use of force or the use of or an armed attack by one country, self-defense does not come into play or is not triggered unless there is an armed attack that has sufficient scale and effect to be tantamount to a regular conventional attack. So if it's just sending guerrilla forces into an area, invading with low-level attacks, then the International Court of Justice in the paramilitary activities case, the US versus Nicaragua, and the oil platforms case, the US versus Iran, those two cases say that when you have these low-level attacks, the victim is not entitled to self-defense unless the attack has a great magnitude. And the terms the court uses in the ICJ is, do these attacks have gravity or scale and effects. If they're low level, then there's no right of self-defense.
Okay, next question is about PMC, Private Military Cooperation. As I understand, right now, lots of those type of cooperation are involved in the conflict in Ukraine. To what extent those activities of those cooperation can be justified in a context of international law?
Yeah, so every armed force has civilians that accompany the force and that are entitled to some minimal POW protections. But these civilians are not permitted to engage in belligerent activities. They're not permitted to engage in attacks. So to the extent that they are doing so, they risk losing their protection as civilians. So these private military security companies are really quite controversial. They are permitted to do some non-belligerent function, like maybe you hire a cook to cook the food or something like this, but they are not lawfully permitted to engage in armed attacks.
Thank you. Next question is, okay, let me read the question. Due to the activation of a Monterey Convention, the Black Sea is now constitutes most of Russian warships and little later US warships because they are unable to enter the sea. So how do you assess the situation?
Well, Turkey has control as long as all it has to do under Article 19 of the Montreux Convention, 1920-21, it has exclusive control. And if it says that it believes that it faces an imminent attack or threat of attack, it can close the straits to all foreign warships. The only exception is those Black Sea states can transit on their way back to their home port. And so those Russian vessels could leave, but no new ones can come in unless there are vessels in the Mediterranean that are Russian, they're home ported in the Black Sea. They can go one time to go to their port. US or these other foreign flag warships are not permitted now to go through the straits. Now, I did write an article for Foreign Policy about this question of, does that violate the rights of neutral states, such as the United States, that has a right of freedom of navigation to go through the straits? I think it's a matter of reasonableness. Turkey does have authority over the straits, and it may close them if it feels an imminent threat. On the other hand, it's arguable whether Turkey feels an imminent threat of attack by the presence of foreign warships. Although I'm not in Turkey, Turkey might say yes, but it will expand or escalate the conflict if a lot of foreign warships come in. And I could see how that might be unsettling.
As of right now, the most important interesting question is whether the Russia President Putin can be brought to justice like ICC, and it is possible. Then how can it be brought to the court?
Yeah, I think it's practically impossible. It's really a matter of power. If it's a very small country and the nationals turn the leader over, then it may be possible. Even then, from a legal standpoint, it's very difficult to penetrate the sovereign immunity of a head of state. Now, genocide and war crimes is, of course, a basis for doing so, just as we discovered in Tokyo with the Tokyo trials after World War II, and similarly the Nuremberg trials in Europe. It's possible to do. but it will be a challenge. I think it's going to be difficult, only probably if the Russians turn him over, because here you have one of the most powerful states in the world with more nuclear weapons than any other country. And, obviously these realities cannot be ignored, even in the legal, in an application of the law. You can't ignore those strategic realities.
Yeah, according to your explanation, we came to know that the power is almost same as the law, but in domestic case, maybe, but may not be the case. Anyway, next question is there any aspect of Ukrainian crisis which the existing laws and rules do not cover? Is there any new law or rule that we need to create? If that is the case, what are they? And how should we make them?
I think that the laws are quite comprehensive. It's not a lack of laws, it's a lack of enforcement of the existing laws. And so there's not a really good mechanism to compel or enforce the rules that we have. But I think that the rules that we have that are in place are quite comprehensive. There are some gray area or disagreement, for example, on neutrality. As I mentioned, how far can a state go to aid one side? Like a number of countries, including the United States, are providing military supplies to Ukraine. Does this violate the law of neutrality? There's a disagreement about it. There's a theory called qualified neutrality, where the idea is it's not a violation of your neutrality to provide aid to the defending country. But, every country would say they're defending. Nobody's going to say they're the aggressor. So it's kind of difficult. So what I would say is that there's not a lack of law. There is some level of ambiguity in the existing law. And then the greatest problem is compliance, because the international community has done a decent job of creating jurisdiction over armed conflict and problems like genocide. So there is prescriptive jurisdiction, meaning the law technically applies, like the law technically applies to Russia in this case. The problem is, getting back to the earlier question, the problem is enforcement jurisdiction. Is there enforcement? And that's really where the problem lies, the lack of compliance and what to do about it.
The ambiguity you are talking about, is it intentional?
Yes.
Not intentional.
Ambiguity?
Yes.
Yeah, it's intentional. The reason it's called constructive ambiguity. It's intentional during the negotiations or even during a case. The parties seek to be ambiguous. They seek to be ambiguous because they don't have a genuine agreement. And so they develop text or language that is maybe read differently by different parties. And because each party reads the same text, but thinks or understands how it applies differently, they're able to have the illusion of an agreement, but they don't really have what is called in the law a meeting of the minds. There's not really a meeting of the minds. It's just that on paper, they both can agree to language that they interpret differently. And this creates problems down the road. Now, what are the advantages of doing so? The advantages of having an agreement are, they have some merit. Having an agreement brings us together, gives us some commonality. We share some language or about an agreement, and it is better than lack of agreement. So that's on the good side. But on the bad side, when you have an agreement and the parties don't really have a meeting of the minds, then when something happens that challenges those terms, each side digs in because they think they are in the right, that their interpretation is the correct interpretation. And sometimes it might even make things worse than not having an agreement at all. Because having an agreement that's only an illusion, it's just illusory, that creates a different set of problems.
Yeah, feels like it seems to be unfair to the country less power. But the essence of law we want to see is universal and is fair, but according to your explanation, yeah, a little bit unfair. The next question is, how do you make sure that laws actually work and are meaningful? If nobody pays attention, then laws are meaningless. I know that the international community is pressuring Russia through sanctions, but whether or not this will actually succeed is not yet certain. Is there historical precedent or precedent plural form in which the international community has successfully protected the value of international law? League of Nations was a disaster. Have we done a better job after World War II?
Oh, that's a great question. So what I would suggest is that just like in international politics, where there is a struggle for power, there's a struggle for power in international relations. In international law, there's a struggle to shape the law, and a struggle for compliance. It is possible to advance the rule of law, but it takes decades to do so. An example is, let's look at the Cold War. During the Cold War, the allied countries, NATO and security partners in East Asia, including, of course, Republic of Korea, continually, decade after decade, would challenge the Soviet Union to comply with international law or international standards. One of the more successful efforts emerged from the Helsinki Accords in Western Europe, where there were specific requirements in order to engage with the West that the USSR had to fulfill. These were represented in the Copenhagen document in 1990 that tried to liberalize both Eastern Europe and even Russia. Now, obviously, they were somewhat successful because a number of those states escaped the Eastern Bloc. West Germany, the Baltic republics, a number of those states did escape, and we're seeing still President Putin's dissatisfaction with that outcome right now. So there was some limited positive benefit, but of course, we see Belarus, Ukraine, Russia now not wanting to accept those advances. So what can you do with countries that are unwilling to comply with the rule of law? The only thing is to cooperate or collaborate to impose costs on them that will hopefully bring them into compliance. And when you have a major powerful country like Russia or say China, obviously it's extremely difficult to do so because those countries have so much economic and political power, military power of their own. No country can do it alone. And that's why there will be some sensitivity at some point, in my view, to the international community of states, but it's obviously it's a very difficult, very difficult process.
Okay, let me read another question. Montreal Convention was made in 1936. This was before NATO. North Atlantic Treaty was not signed until 1949, and it was not until the Korean War that the North Atlantic Treaty actually became an organization. If NATO ever entered into a war against Russia, how would this affect Turkey and the Turkish Strait? Next question is, will Turkey automatically become a belligerent? If so, which article of Montreal Convention applies? Does this mean anything for international law regime for the international community?
Yeah, it's a great question. Turkey does have control or plenary authority under the Montreux Convention and customary law. As a NATO member, Turkey would be a party to the conflict. It can close the straits to selected countries that are threatening to Turkey, and it can allow its allied states to go through. This is ultimately a political decision that Turkey would have to make. If you had a conflict where some countries, let's say United Kingdom, was in a conflict and Turkey didn't agree, then it's a legal issue as to whether they would have a right to go through. My view is that legally, Turkey can control all of the traffic through the strait.
Okay, thank you. The following question is about R2P, the responsibility to protect. Yeah. This concept is highly contested in both the policy realm and academia. The US claimed that it will not directly intervene militarily in the war because Ukraine is not a NATO member state. The UN cannot intervene because there are China and Russia in the United Nations Security Council. However, can there be enough justification for the international community or some committed state to provide direct military support under the R2P norm? In general, how does the R2P norm relate to international law?
Yeah, it's a great question. Thank you. So I would suggest that aid can be provided even without R2P. That is, there's already a number of countries that are providing military aid, for example, to Ukraine. As far as the norm of R2P, may I place it in the broader context? There are 5 potential justifications for the use of force in the UN Charter paradigm. I put 2 of them up in my slides, 2 of the main ones. Number 1 is that all states have the inherent right of self-defense. The second is that self-defense may be used until the UN Security Council comes to the aid of the defending country. So those are 2 instances, UN Security Council or self-defense. 3 others are not universally accepted. R2P, there's also the protective principle, where a state can try to protect its nationals overseas. This is an example like in the Israeli raid on Entebbe Airport at Uganda, where Israeli commandos tried to rescue or protect its citizens in a foreign country. And then the third one in this category, second tier, is Chapter 8 authorization. So the widely accepted rationale for the use of force under jus ad bellum is self-defense or Chapter 7 resolution under the UN Security Council. UN Security Council taking enforcement action. Both of those, everybody agrees, are lawful uses of force: self-defense and UN Security Council. The three others do not have wide acceptance. R2P is not widely accepted as a basis for the use of force. The protective principle is often not widely accepted because it's not permissible to violate the sovereignty of another country just in order to protect some small number of your citizens. And then finally, regional arrangements or regional organizations under Chapter 8 of the Charter may take action against regional threats, but the action cannot be enforcement action. What does that mean? Well, nobody's really sure. They can take some kind of action, but it appears like it's not enforcement action, maybe not military action. So these last three rationale for the use of force are not widely accepted. They're actually considered quite weak and highly debatable.
Okay, maybe last question from myself. There is the principle of indivisible security, which is a collective concept. So if we apply those concepts to China and Taiwan, do you think China will invade Taiwan in the near future?
Well, nobody knows, obviously. I think probably not, because China prefers to subdue its enemy without having to fight. You know, this is the classic stratagem of Sun Tzu, which is the acme of skill is to defeat your enemy without having to fight them. And China is very effective at integrating its potential adversaries into a global economic network that it controls, the Belt Road Initiative, for example. It's also quite effective at eroding social structures, such as providing fentanyl, illegal drug use in Europe or United States. So I think it's unlikely, or it's less likely, that China will invade Taiwan, but obviously, of course, it's possible. I think China has the very long view, and it's willing to wait some amount of time.
Just one more question just arrived. Let me just give you just one question. Yeah, then
Sure.
You can retire for the night. There are several means to ensure compliance with international law, such as norm internalization, concern for state reputation, sanctions, disallowing certain benefit from a state unless the state complies with certain norms and the standard, etc. Which tool has been the most effective and successful in dealing with a country like China and Russia?
I think that with countries like China and Russia, they're very powerful. If it's a very weak state, then obviously you can take different measures and they might be more effective. I think it's for a major power or a great power, clearly the only option is a combination of carrots and sticks. And so trying to think of examples with regard to China, there are carrots offered and sticks on occasion. It's very difficult to positively identify whether China's behavior is a result of certain policies. Ultimately, I guess I would say that the job is always easier. So the objective is deterrence, to deter bad behavior. The job is always easier if you are in a stronger position. And that's why I would suggest that it's imperative for countries that are facing a implicit or explicit threat by Russia or by China, that they are as strong as they can be militarily, and even more importantly, economically, because economic power undergirds military power. So there's many examples of where countries have failed in this, in my view. Right now, I don't think the United States is optimally positioning itself to be as militarily and economically as strong as it can. Another example is Ukraine. Ukraine was invaded in 2014, and it has done some preparation over the last, over the intervening years, over the last 8 years. But really, I'm sure if Ukraine looked back, it would have prepared even better, more strongly, and might have been able to even deter further action by Russia. So you look at a small country like Israel with a very, very powerful, effective armed forces. You would think that after you were invaded and part of your country was occupied in 2014, Ukraine would suddenly have a very large military national conscription, receiving military hardware from other countries, training, and this sort of thing. And I think it probably could have done more. So the bottom line, in my view, is that it's always better off to be stronger.
Yeah, I guess time to call it a day. Jim, how can I thank you for the brilliant expertise you have shown us in your presentation and also in a Q&A session.